Good morning, and thanks for joining us here on Condo Solutions. Monday mornings, 9 to 10 o'clock, we talk about condo stuff. And we're here to talk about some of those confusing issues that affect you in the day-to-day world of condos and HOAs, some of the things that you have to deal with or work with, and some of the questions that you may have. We have a great person to answer those questions, a guy that's been doing this for hundreds of years. He actually etched the first condo docs on stone. That's how long he has been doing this, and he brought it down from a mountain and provided it to the first condo board, who looked at that stuff and said, we're following these documents, right, Peter? So Peter Mullengarden is our attorney here in the show. For those people that are regular listeners, you know that. You know, Peter gives you the answers most of the time, so that's what we like about him. He is a one-armed attorney. It's just on this hand. So anyway, we like to have him give us an answer, and he does. And you can call him and get that answer, 220-9788, 220-WSTU, and we'll be happy to address your issues and answer as much of your questions as we can. All kidding aside, we try to do the best we can to give you an answer that you can use, but we don't have your documents, and so therefore we can't always give you a rock-solid answer, so to speak, because we don't always know what your documents say, and your documents can change or override certain provisions of the law. So it's important to have the documents looked at. So if you're going to court on something or going to make a decision on something that could result in court, you really should contact your attorney or contact somebody like Peter and ask them to review your documents and give you an answer based on their review of your specific documents and your specific situation. So that way you'll have an answer that you can rely on. But otherwise, we'll give you an answer, what we call a radio answer. That's an answer based on the information that you provide, along with other information that we know relative to state law and common practices. And but you guys listen to the radio on a regular basis. Some of you listen to Mike in the morning here, and so you know that information is not usually reliable and can't be relied on in most cases. So you just Mike, where are you? You missed that.
I chose to ignore it.
Oh, okay. Sorry, I was taking a slam at you on a Monday morning, and you're just drifting off thinking about something else.
I chose to ignore it.
Oh, okay. Sorry.
Trying to be the better man.
All right. Well,
we all choose to ignore him. Don't worry about it.
But anyway, so we're here to help you is really what it boils down to. And Peter's been doing this for a long time, and he will give you the best answer that we possibly can so you can help figure out how you handle your situation. My name is Mark Breckville. I'm a local CPA and a licensed community association manager. And as I mentioned, Peter Mullengarden is our attorney, and he is the one that will help us with our legal questions and all of the things that you want to ask about. Peter, I this time of the year, I always get an opportunity to look at some things, to read some minutes. I always love to read minutes, and so that's it's amazing from an audit perspective. A lot of times with condos and HOAs, you can find out an awful lot by reading the minutes because, first of all, there's way too much stuff in there, and they report it all, including what Sally was doing next door to Joe, and how their dog did something really disgusting, and all those kind of good things. But anyway, it was it's very interesting this time of the year, and we talked a little bit about some of those things. But a couple of things I want to throw out there and see what what your thoughts are, and maybe see if our listeners have thought about any of this stuff. There was the common one that I think I've read 3 sets of minutes so far this year, and one of them already has had a dog issue. So I think one of the things to probably just go over again is what restrictions you can place on an emotional support animal, even though in this case it wasn't labeled as such. And it was interesting, Peter, I'll throw this out there as well. I don't think I've ever seen this before, and I don't remember. From the documents, I don't remember if I looked back at the documents to see how they were exactly worded. but this association doesn't have a specific restriction on pets, and but it does have. But to have a pet, a unit owner has to have a license issued by the board of directors, which the board of directors have, I guess, some certain procedure that they follow. But if the animal and it's basically the basic criteria is that the animal can't be dangerous or disruptive. So they'll issue the license to an animal. But if it turns out that it's aggressive or it barks and it's a nuisance or whatever, then they have the right to remove the license, and the person can't have the animal there on premises. What do you think about that? Have you ever seen something like that? And does that work, or is that a problem?
Well, first of all, in order for this issue even to be an issue, in other words, in terms of do we allow the assistance animal in or do we not allow it in, the request, it has to be an accommodation to a restriction against animals. Okay, so if you don't have a restriction against animals, there really is no issue. But
okay.
I guess here you're saying that, if I understood you correctly, that this particular association doesn't prohibit animals per se, but says they are permitted if they are not a nuisance, something like that.
Right. Yep. If they're not a danger or a nuisance, I think is how it's set up, and the board has the ability to issue a license, and then which would allow them to bring their animal in, and then can remove.
Well, under the current HUD guidelines, which apply to communities, which apply to communities that are deciding whether or not to grant the accommodation. Again, grant the accommodation to the typical pet restriction. And under the current HUD guidelines, an association or a housing provider can deny a request for an accommodation if the animal is an unreasonable burden on the community. And now the way they define it is that it's literally attacking other people or animals or destroying property. The HUD guidelines are, in my view, a little bit out there, but they are guidelines. They're not administrative rules, but they are looked to by some courts almost as such. Certain things are not applicable to the assistance animals, which include emotional support animals, by the way, just like seeing eye dogs and other assistance animals, in that weight restrictions, breed restrictions are not applicable to these animals. No, I think it's reasonable, and again, how much pushback you get on this to indicate or to provide that the animal must be leashed whenever outside the unit and on the common area, common elements. Must be walked in a certain area perhaps, and must be picked up after. Now, I throw in, typically that it cannot unreasonably disturb other owners by aggressive behavior, barking, or otherwise. Okay, now that's unreasonably. Dogs are not silent.
Right.
They bark occasionally. So they're not expected to be, absolute silence. Again, HUD goes a little further. Now, HUD also said that you cannot deny an animal on pure speculation. In other words, because it's of a breed that may have a reputation for being aggressive. That just because the animal is a pit bull or pit bull mix or something, or whatever, a Doberman or something, that that according to HUD, you can't deny it just because that breed or that type of animal may have a bad reputation. But so you got to you have to kind of play it by ear. I don't think you can deny a dog again on pure speculation, or again size or weight or something like that. You also cannot, if you charge like a pet deposit or something like that, you can't charge that deposit or that charge or that fee to the assistance animal. So they are treated as not pets.
Right.
They are treated as assistance animals, and therefore not subject to those type of pet restrictions or pet rules.
So so in this situation, it's interesting because I think it's interesting. This is, I think, a unique way to, or an interesting way to handle the issue. In other words, you don't have a prohibition in your documents against pets.
Well, if you don't have a prohibition, let me just address that 1 second. I'm sorry to interrupt. There was a case out there. It was Gordon versus Palmer, number, I don't know, 2 or 5. Anyway, and in that case, that particular declaration said that no animals without board approval, basically. Okay? Mm-hmm. And the association generally just did not allow. Actually, in this case, I think they did actually have criteria. But anyway, that type of rule cannot be treated as no pets. I mean, if your documents say no pet without approval, that means the board must establish criteria.
Right.
For which pets will be allowed and which pets will not be allowed. Reasonable criteria.
Right.
But I have associations in the past that have that kind of language. No pets without approval means no pets.
Right.
And it doesn't. So I just want to make that point. All right, go ahead. I'm sorry.
Okay. No, well, that's a good one, because that would be then what you would do is that, like in this situation, they so right away any animal would be, everything's up above board because everything is pretty straightforward as long as the board's criteria is consistent and reasonable. Which of course not always the case. But if you have a situation where, in effect, they issue the license and don't judge the animal in advance, but then have the right to remove it if the animal becomes a nuisance or a threat, then at that point the only argument would be is if somebody got their license revoked, they could potentially come back and argue it was an emotional support animal, it was outside of the provision. But if the reason they got it revoked was something that would have gotten it revoked or kicked out if it was an emotional support animal, then you actually are in pretty good shape, Well,
if the animal turns out to be an assistance animal, okay, emotional support or otherwise,
right,
and the association was saying no to the animal, or the animal has to leave because of noise, aggressive behavior,
right,
whatever, okay,
right,
and the owner of the animal challenged that,
right,
then it'll be up to whoever whether court or arbitration or whatever, will be up for the finder of fact and the judge, arbitrator, whoever, to determine whether or not that animal was an unreasonable burden on the community.
Right.
And that's a case by case basis. That's just very hard to predict.
But
impossible to predict.
But if your criteria as a board for issuing a license is reasonable. In other words, the animal has been shown to be aggressive and towards children or other animals, and you'd have to have documentation of that, or the animal was constantly barking, barking and barking all day long, and or the situation where you've got where you've got the dog is just maybe a nuisance to the property, and that's the other issue, is where you get a situation where it's a nuisance to the property, and you can document that. I mean, it's funny, this particular situation was actually a property nuisance issue that they were dealing with, and it had to do with the dog going to the bathroom in the elevator on a constant basis. To me, that's probably destructive. The potential problem of because they're having to repair the unit all the time. But But anyway, so I think it's an interesting thing. I'll throw it and at least mention it for our listeners. That's why I wanted to bring it up, because I think it might be a good way to approach this issue. Then you don't have to deal with certificates and permissions and all of that. You've got very specific. Although if your documents prohibit pets to start with, then you're dealing with it. So, but I mean, I like the way they did this one. I don't know how hard it would be to modify your documents to have this be the case, but to me it seems a good way to do it. I mean, it's I think something like that where you give a little bit of authority with specific rules and regulations, maybe even to the point that the rules of what's considered aggressive or is at least outlined in your document someplace, so in a general basis that so that it stays legal. But anyway, so we have a caller. John, go ahead.
Good morning. Thank you for taking my call.
Sure, no problem.
Wanted to ask you, at my property down south, we have our elections coming up next month in March, and we have a board of 7, and we have 3 open positions and 4 or 5 people running for those 3 open positions. When we have new people coming into our association, at orientation screening, we do a criminal background check, and we also do a credit check before approval of new people coming in. I was wondering what your take was, because we have since found out that one of the candidates that's running for the board has a criminal history. And I was wondering what your take was. Should associations, and do you think it's a good idea, and should we be doing criminal background checks on board members that are running for the board or actually serving on the board?
Well, my initial reaction, and I'll throw it to Peter because he'll probably have something that's a little bit better than this, but my answer would be if that person is elected, they're in charge of enforcing your parking requirements. So that's all I'm saying. It's get somebody that really knows what they're doing, right? That's got a criminal record. They'll take care of your problems for you. So, but I think the law does address past criminal activities. So, Peter, go ahead.
Well, the law says that anyone who is a felon, either in any state or any territory of the United States, and has not had their civil rights restored for 5 years as of the date that they are running for the board, that they're not eligible to be on the board.
Misdemeanor's okay, not felon.
Misdemeanor's okay. Yeah, it has to be a felony. Or accused of stealing from the association. Okay, just accused. I mean, accused as an indictment or arrest, not, hey, I think you stole. But you don't have to be convicted if it's an embezzlement or stealing from the association. It's just you've been arrested or indicted. But misdemeanors are okay. So I think associations should, quite frankly, do background checks on candidates to make sure they're eligible, because it is an eligibility requirement.
Right.
And I have no problem with that. If it was not an eligibility requirement, I would say no, because they're already owners, and what are you checking on them for again? But since it is an eligibility requirement, I have no problem with it. In fact, I think it's probably a pretty good idea to make sure all your candidates are eligible. I mean, one thing that some clients tend to forget is you also must be current in all your payments.
Oh, yeah.
You can check on that too. So, that's my feeling on that issue.
Great, you've answered my question. So you think it is a good idea to do a criminal background check on
Yes.
board members and candidates as well?
Yes.
Even after they've been on the board, if you're doing a background check on your candidates, you do it on your board members that are already on the board.
Well, yeah, to make sure that they're still eligible. Quite frankly,
right.
Yeah, because those are overriding provisions and and that affect eligibility. So at that point, anybody who's volunteering to run or is currently seated, you would have to you'd have to at least periodically check to make sure. What's also a good idea, John, is to have a annual board statement that all board members and candidates would sign off on, attesting that they meet the criteria and spell out what it is. so that way, if somebody has been convicted of something on an interim basis, and people say, "Oh, what's the chance of that we wouldn't know?" Well, you know what? The funny thing is,
it's a good chance.
Yeah, we have a lot of, I hate to say it, but we have a lot of people that end up down here from up north, and they get involved in some kind of SEC deal or business deal, and lo and behold, some
people are reluctant to tell you that they're a convicted felon.
Oh yeah, no question.
So
and
now, Mark, that's not a bad idea. Although I don't know if there's any way to compel or force someone to sign that statement.
No, but it's we have in the nonprofit world we do it all the time in terms of just because we're required to. We have an annual statement, conflict of interest, and that's another thing and that's how I would look at it from a governance standpoint. On an annual basis, I would probably have my board members, sign a little bit of a disclosure statement of that that they meet the current criteria to be a board member, and that they understand what they are. I know they're all supposed to know that anyway, but they don't. So what those rules are, what the provisions are. Also, that they don't have any conflicts of interest, that they disclose any business relationships or relationships that they might have with vendors or somebody else that would potentially create a conflict. And that they have that kind of information, and then you just update that annually anyway, because and then the board would have a right to check on that stuff too. I mean, the management or the board would have a right to check on that. But I think it's always a good idea just to remind people, because sometimes people forget, or they're not business people, so they don't understand, that hey. I pushed my lawn guy because I really like the guy, and I got him in here, and he's a really good guy, and he's and then he's giving me a discount. Well, yeah, you're not supposed to do that, So,
but I agree. I think it would be hard to get someone to sign that kind of a statement. In fact, if you have a board member or two that don't even want to commit to taking the condo certification course, how are you going to get them to sign a document like that?
Well, the only people I've ever had trouble getting to sign those documents on conflict of interest were attorneys. Because they have to run a conflicts check. But seriously, though, John, I mean, first of all, that is not a if all that says is that you're not a convicted felon, you're not past due on your dues, whatever the criteria is, that you're the unit owner still, or whatever the basic criteria is in your association for being a board member, all they're signing off is that they meet that. I don't think that that's an unreasonable issue to ask, and I think it can be a requirement for running for the board, because that is the requirement to run for the board. So to ask somebody to sign off that they meet the criteria is not an unreasonable request. And so therefore I think it could be something that you do. And for the board members to have to sign that so that it indicates that they still are a member. For example, some board members transfer. The association has a requirement that you've got to own a unit in the association, and then they transfer the unit to somebody else. They transfer it to a cousin or family member or somebody else, or they're having financial issues and they transfer it into somebody else's name temporarily, and they're not going to tell anybody because they don't want anybody to know. But you have a right to know as a board member if they have to be a unit owner to be on the board. Now, some associations, of course, don't. But so I don't think that's unreasonable. Peter, do you think that's an unreasonable request to make them sign something like that to run?
You can request it. But you can't require them to do it.
Why can't you if that's a requirement to run for board?
It's not a requirement. It's a requirement to run for the board, but it's not a requirement. I mean, you can do a background check. You can try to find out, but I don't think you can compel them to sign anything. In other words, if they refuse to sign it, I don't think you can stop them from running.
Well, yeah, my point would be that you're asking them to tell you that they meet the requirements to run for the board. I think it's reasonable legally to ask a person.
I didn't say it wasn't reasonable to ask them, but I don't think you can compel them to sign.
Well, I think if they don't sign, I would argue
do a background check.
Yeah, but I think if they didn't, well, yeah, but Yeah, I guess so. But that's a lot of cost to the association.
Look, I used to have clients that wanted board members to sign loyalty oaths. Okay, I said that's a nice idea, but you can't compel them to sign anything.
Well, and there's no
conflict of interest, no this, no that.
Yeah, I mean, but and technically, I guess, statutorily, there's some, duty of loyalty and that kind of thing that again, you can require that they have to know that. But I think that's different than asking somebody, do you meet the criteria to run for the board? That's all you're asking. I mean, I don't think it's unreasonable for an association to.
I didn't say it wasn't unreasonable.
No, but I mean, if they don't sign it, I don't think it's unreasonable for the association to say, well, if you won't say that you're eligible to run, we're not going to let you run until you tell us you're eligible. That's what I think. I mean, personally, I can't.
Maybe it'll hold up. I haven't researched it. Okay.
Well, it's probably not been in court yet, but it's an interesting situation.
But there's nothing in the statute that says that.
No,
okay?
I know.
And oftentimes they just go by the plain meaning, the exact words of the statute, and they don't go beyond that.
I know.
On the past due, it's more than 90 days, correct?
No, that's delinquent as of the day you're running.
Yeah, it's not the 90 days anymore.
They took out the 90 days.
You can be 1 day delinquent, and it might be like an interest thing, accumulated interest of $1 or $2.
Make sure you're current.
Yep.
And you're not eligible.
Yep.
Make sure you're current.
I see.
I had an association where the individual was it was just what you were talking about. They were out. They'd been on the board forever. They were out out of the area for the summer. Paid their dues on a regular basis. Paid stuff on a regular basis. They had there was a increase. They had an automatic payment set up, and there was an increase in the payment of $50 or something like that, or $10. And so they ran their automatic payment, forgot to change it, the amount, and they were $10 short. And it didn't come up until they were getting ready to do the board elections, and they determined that the individual wasn't eligible. And that person had to drop off because they couldn't. There was no way to fix it at that point. That you can't. It was too late to fix it, and so they were done. So they had to sit off a term because they were $10 off on their, and it was very explainable. The dues had changed slightly, and they were paying electronically. In fact, they were usually paying in advance. Now, they argued the association should have let them know that they were past due, but it had really just happened. It wasn't that long ago, and so in the association it was $10. The association wasn't worried, but they didn't think about it from an election standpoint. So yeah, that's one of the things you want to make sure if you're going to run for the board, that you just need to check your records to make sure that and it might not be your fault, you might not have known, but if you're past due, regardless of what it is, a small interest charge, whatever it is, you're going to have to deal with it.
Well, thank you very much. Appreciate it.
No problem. Thanks for the question.
No problem.
Bye now.
Appreciate it. So yeah, Peter, that's an interesting interesting thing.
Yeah, because the statute says, both of them, HOA and condo, say if you're delinquent in the payment of any obligation, you're not eligible to be a candidate, and you're not to be listed on the ballot.
Yeah.
So it used to say 90 days, but
right.
That was
and
that was taken out.
And and I think you told us that there was a situation where you can't automatically, or you can't force a situation like that, by not telling the person, or by purposely keeping it hidden, or whatever the situation is, because and I've heard people say that they got a candidate running that they don't want they don't want on the board. And, of course, the person is complaining about, usually the reason they're running is they're complaining about the dues being too high, or special assessment, or whatever the deal is. So they're running on that platform, so they don't want to pay theirs anyway. So they wait till the last minute, and it's after the time to be a candidate, declare to be a candidate, and then what happens is they get the person's check and they process it 3 days late or something. So that they're past due. and you can't do that kind of stuff. That's illegal. So don't be doing that. So I just mentioned, because I know somebody out there's thinking of a way to try to get somebody off the board, and that's not the way to do it. But because that probably won't work. I wanted to talk to you, Peter, about another issue. This question was a good one. 220-9788, 220-WSTU. If you have got any other questions, because we're here to answer your specific questions. But the other issue that I wanted to deal with this morning, or see what your opinion is on it, just in general, is we've had now two. We've had 2 years in a row where we've had a hurricane, and of course this last one was pretty significant in terms of damage. So especially down south. The interesting thing is, up here in Martin County, we don't really have the huge damage that we had back in 2004 or whatever else. We didn't get hit that way. But we've got some associations that have damage, that have some significant damage, particularly to individual units or to roofs or things like that. And in particular, we've got some associations where they were about ready to have roof work done anyway, and now they lost the roof or it's damaged to the point that it doesn't make sense to repair it anyway because they're going to have to replace it. So here's my accounting issue that I'm going to throw out to you to see what you think about it as a professional in the industry. I've got an association, two associations, believe it or not, side by side. The one, best we can tell, had about $50,000 worth of damage, okay? And it was mostly miscellaneous little things. These are oceanfront condos, so their deductible is $500,000 or $600,000, somewhere in that range at least. So that 52, it's going to be under the deductible. We know about what it is, not fully what it is. That association also was already going to repair their roof. So I don't think they had any significant roof damage that would qualify for insurance or anything else, but they're going to have to repair their roof anyway. The one next door had significant roof damage. They got multiple buildings with multiple roofs, and they had significant damage. They don't know what the total is right now, but they, right now, and they're arguing with the insurance company because the insurance company's saying it's only 2 roofs, and, they're trying to say it's 9 roofs or whatever the deal is. So they don't know for sure what's going to be insured. They do know that there's damage to, or that, 8 or 9 roofs are going to have to be repaired. And we're talking, let's say, $900,000. So the question that comes up is this. From an accounting standpoint, the question is, when do you record the expense and or the event? And here's what the accountants struggle with. Accountants don't typically record an expense or income until, first of all, they know it's true, it's going to happen, and they know the amount. All right? So, and that amount thing is a little bit iffy because it depends on how you classify the expense. For example, if I know for a fact that the roof is going to have to be repaired, and I know within reason that the roof is going to cost about $100,000, and my question is it 6 roofs or 9 roofs? So that's why I don't know if it's $600,000 or $900,000. You could look at that as one item and say, well, I don't know how much it's going to be yet, so I'm going to disclose it, but I'm not going to put it on the income statement balance sheet. Or you could argue, well, I know 6 of them have got to be repaired, and I know what the cost is going to be there, and that alone is an amount equal to the deductible. All right, so I know for a fact that they're going to have to pay the deductible. So I know I'm going to have at least this much. So I'm going to record this much, and the other 2 or 3 I'm going to disclose, but I'm not going to record. All right. So the issue there would be that in the first situation, that I don't know how much it is in total, and I decide it's one activity, I wouldn't show anything on the financial statements for the hurricane. All I would have is a footnote in the back that would say something to the effect that the association was impacted by hurricane, whatever that one was, Irma or whatever, and that the extent of the costs associated with that and the insurance recovery, if any, is undetermined at this time. That's the kind of thing that you would put in there. And then, and you might be able to disclose, but probably not. You wouldn't even disclose the potential amount because you don't know what that amount's going to be. So that would be the first situation. So you pick up a set of financial statements from 2017, 4 months from now, when you're getting ready to buy your unit, and it doesn't say anything about a hurricane even hitting or that your association even had damage. And you've looked at 7 other associations in Martin County, and none of them had any hurricane damage, so you're not worried. And now, or you have a situation where you've at least shown that there's going to have to be money coming out of reserves or a special assessment because there's at least $600,000 worth of damage, which is not covered by deductible. So what you would have on the financial statements is at least a recognition of the fact that the association had a loss that was uninsured, at least equal to their deductible. And so that would show up on the financials. You'd probably create a hurricane fund. You would show, no revenue coming in, and you'd show, the amount that you knew that you were going to spend for sure, and then you would disclose that there could be additional amounts. So I'm just throwing that out there. Personally, which way to go. The industry argues about this. There is no answer to this. The industry argues about this all the time. Every time we have a hurricane, we argue about this. My argument has always been, I cannot understand issuing a set of financial statements when you had a major event and the financial statements don't address them. Other than in some small footnote, you've had a loss. How do you argue that you had a hurricane loss the year after the hurricane? To me, the loss occurs when the hurricane occurs. That's when you would record the potential expense and an estimate of the recovery. If some portion of that was going to be recovered through insurance, I would record the income at the same time. But I have a hard time just leaving the events off. But if you go back to 2004 and 2005, there's financial statements out there that don't show that the association had any damage at all, any problem at all, and the association just avoided getting red tagged the next year. So, and people bought units in there not knowing that they were going to be facing $50,000 special assessments or something, So, but the accounting is not, it's what's called a contingency, and you don't record the the contingency until it's until for sure that it's happening and the amount. So anyway, what's your thoughts, Peter? Just as a lay person, but that works with the industry, what would your thought be on something like that?
Well, to me, I always look at it has to be something that makes common sense.
Right.
I know it's shocking, right? And I guess what the whole point of the financial statement is to show what? The financial condition of the corporation, of the association, and what loss did they incur in that year, right?
Right.
That's the basic, okay. And as you said, sometimes you have a loss, you just don't know what it is, though.
Right.
Because the insurance claim isn't settled, so you don't know what proceeds, if any, you're getting. Your claim could even increase as you discover more loss.
Right.
The loss happens in 2018, let's say this year, and then for whatever reason you really don't know your entire loss until maybe 2019. In case, it's whatever, but
right.
It's possible. I guess for me, I think the report at least has to note the loss occurred, okay, and then go into whatever detail is necessary and indicate, what the loss was, or if it's unknown, that there was a loss, and the extent is still being determined. Maybe with good faith estimates, whether it's going to be above or below the deductible. I don't know, something like that. I mean, I don't know if this needs more legislation or more regulation from the accounting side for you guys, to give you more guidelines. Now, I guess let me ask you, so if the loss occurs in 1 year, but the actual loss isn't known until the next year, when they actually receive money or whatever, how is that reflected? Is that reflected on on the next year financial report, or?
Yeah, here's what would happen is that, and you kind of summarized it pretty well in terms of what the purpose of the financials is, and there. We probably, this is one of those kind of things for accountants where we want principles-based accounting, but this is one of those ones where we don't. We want somebody to tell us. But the answer is that there is actually two answers to this probably, and probably a lot of it has to do with how well you disclose it, depending upon which way you go. But what the financial statement should reflect is if the association has suffered a loss. It doesn't necessarily, or a big gain, I guess, but in this situation, there's no way you're going to have a gain. All you're going to have is a recovery of expenses. So in my opinion, the only thing that you have is if you had a hurricane, that hurricane is what caused the loss. So the loss had to occur. The economic decrease in value had to occur at the date of the loss. Presumably, that's what happened. That's how you define a loss, really, is the reduction in fair market value of the property, prior to the, from just prior to the event to after the event. What's the reduction in the value of the property? That's technically the loss. Now, we don't have fair market value financial statements, and the property that incurred the loss is common property and isn't even on the balance sheet. So you can't show it as a write-down of the asset or whatever, you know what I mean? Because it's not on the balance sheet to start with. So my thing from and you also got to know who's using your financial statements. If it's the board, they know they had a loss. If it's somebody in the unit, they probably know they had. I mean, if it's somebody that already owned in there, they knew they had a loss because they heard the discussions, or they at least had information that let them know what was going on through the board and through the association. Most likely. Not always, though. Some people aren't here all the time, And then you've got people who are buying in. To me, I think the users of financial statements are the existing owners. They're not the board members. The board members just pay us on behalf of the association and hire us. But it's the unit owners are the ones that we're responsible to, and potential unit owners, I think, are who, because those are people who are going to buy in. I would add creditors to that, but most associations don't have creditors. So to me, it's it's those people. Now, I would say there is a third party in this thing, is potential creditors. If you got $900,000 worth of work that's got to be done, and it's uninsured, or a large portion of it's uninsured, and there's not money sitting on the balance sheet, and I'm the creditor I'm the contractor that's looking at doing the work, I might ask for some money up front, you know what I mean? Because I might not get paid. I don't want to get behind on this job because I know that they've got a special assess, and they may or may not be able to collect on that assessment. So, and then the other issue is, if the board has already assessed. For example, 12/31 year end, most people may not have really had a full handle on what was happening. Now in February, they've got a better idea what the loss is going to be. They still don't know, and they put a special assessment in February to assess for the damage, for the deductible. So there's a question. Okay, when do you record that assessment? When it was incurred because of the damage, or so you match it up with the expense to say, okay, we're going to cover this. We've done a special assessment to cover it. So there isn't really a right answer. I think that's the problem, and a lot of it has to do with disclosure. But I just I personally think that you record the loss in the period that the loss occurred, which was when there was a hurricane, and if you know for sure that you're going to have some portion of the deductible. I mean, you may not know what your full costs are, but I think you know at least what your partial costs. You're going to, like in the first association, they've got roughly $52,000 worth of repairs. And we know that's not going to be covered by insurance because it's way below the deductible, So the issue there is, is it just immaterial? We don't mess with it, or is it something that we go ahead and just record? And if it's off by $5,000 or $10,000, you adjust it in the next period. And that was your question. So what do you do later on when you have a recovery? Well, if you've got an insurance recovery because the item turns out to be above, it means that any expense that you're going to record, you're going to have an insurance recovery for. So really what you're trying to do is, in this case, is really identify the loss, which is an expense number. Insurance just mitigates the loss. So, it's going to reduce the loss. And how the association is going to handle it. Are they going to pay it out of reserves, or are they going to pay it out of a special assessment, or both? Is down the road is going to be the question. But the fact is they had a loss, and you know that it's not covered by insurance. So I've always kind of sided towards putting as much as possible on the basic income statement and balance sheet, because a lot of people don't look at the footnotes and they don't get into that in detail, and a lot of times there's not a lot of information that's put in the footnotes because they don't have to. The association doesn't have to disclose it, and most associations aren't too eager to disclose the fact that they might have a $600,000 special assessment. Especially if they've already had a couple of them. So I kind of fall into that category, but I will tell you, a lot of the guys I'm on the Sierra committee with, their argument is to not record anything. They don't record anything in the current year, and then they wait until the next year, or in some cases the year after, when they know what the numbers are, and then they record it. So you had a hurricane in 2017, and in 2020, your financial statements show the effect, and show something like that. The other thing that's interesting, Peter, is that the association is supposed to be on an accrual basis, and whether you have an audit is based on your revenue levels, right?
Right.
Which includes insurance reimbursements. So if you've got an insurance reimbursement coming, you're supposed to book that when it's coming to you, not when it's paid, but when it's coming to you. So if, let's say in that case, there was $500,000 worth of damage, and it was all covered by insurance, then in that case you would accrue the insurance portion. You'd show the expense, you'd accrue the insurance portion, and you would record it as income. And at that point, because the audit requirements are based on gross income, not net income, that would net to zero, they should have an audit for that year. So you could be in the middle of 2017's financials coming up this month, determine that you have that kind of situation, that they're going to have a $100,000 insurance reimbursement, which you're supposed to book when it's earned, which is when the damage occurred, and now you're in the midst of doing a review and you should be doing an audit. You know what I mean? So it gets kind of complicated. This whole thing with a hurricane is kind of unsettled, but I think that's I think your answer is I think what most people would say is common sense tells you if I had a hurricane, God, did I have damage or not? At least have something that shows that it happened. I've seen financial statements, Peter, where it doesn't even show that the hurricane happened. They don't even put a disclosure in there, other than something that, they had, had some damage, and there's nothing specific. It's crazy. But anyway, well, that's a topic for another time, but at least we had some really good topics today and a good question. So hopefully our listeners will join us again next Monday with some more questions and any other issues they want to talk about. They can chime in on that hurricane issue I threw out there and see what they think. And we can talk about it next week here on the show because we're here every Monday from 9 to 10 o'clock right here on WSTU Digital 1450, Martin County's Heritage Station.